I'd like to raise your right hand, please. Do you swear that you tell the whole truth, the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. You're duly sworn. We welcome a group from DCED, Mr. Reddig and Bernadette Barratini and Tim Anstine, and ask you to start your presentation. Thank you.
Thank you very much, Chairman Michael Berger, members of the Senate Local Government Committee. Thank you for the opportunity.
Your microphone, Fred. I'm sorry.
Okay. Thank you for the opportunity to provide testimony today on the Local Government Unit Debt Act. Also with me today is Tim Anstine, Deputy Chief Counsel for DCED, who currently administers the Local Government Unit Debt Act. And I'm going to refer to the Debt Act by its acronym LAGUDA, just to try to save a little bit of time as we go through. And also with us is Bernadette Barratini, former Deputy Chief Counsel in the Department of Community and Economic Development, who administered LAGUDA during her tenure with DCED. I'd like to first of all provide a brief overview of debt-related issues from a local government perspective. The majority of local governments need to borrow at some point in order to fulfill their responsibilities in providing for the health, safety, and welfare of their residents. Prudent debt management is an important part of municipal financial management and the overall administration of a municipality. It involves planning, budgeting, accounting, and public relations. Proper debt management can mean the difference between controlling debt and being controlled by it. If and when a municipality incurs debt, it should do so only with proper planning and an awareness of the impact the debt will have on its overall finances. Debt commits future revenues to its repayment, requiring elected officials to make appropriate provisions far into the future. Without proper perspective and preparation, a municipality's debt, as with any household budget, could get out of hand and create financial difficulties. It is also possible to back unconsciously into a difficult financial position by accumulating year-end deficits, much like a household may overextend its use of credit. Proper debt management can avoid these problems. There is no hard and fast rule for determining when to borrow. Local officials must make that decision given the circumstances, the community's priorities, its financial capacity, and other available options. However, there are some general guidelines to follow in making those decisions. First, consider how the borrowed money will be used. Will the borrowed funds be used for long-range public purpose? Local governments may only spend money for public purposes. Furthermore, with only a few exceptions, state law permits local governments to borrow only for capital projects. The exceptions are borrowing to fund a unit's unfunded actuarial accrued pension liability, self-insurance pools, to pay for a countywide reassessment of real estate, or to borrow in anticipation of the receipt of tax and other revenues during the current fiscal year to address cash flow needs. With court approval, a local government may also issue unfunded debt to pay off unpaid prior year's obligations or legal judgments. Second, only incur debt to finance a project that returns benefits to the community throughout the term of the debt. In other words, the public should reap the benefits of the project at least as long as it takes to pay for it. State law limits the life of a debt issue to 40 years or the stated useful life of the project, whichever is shorter. As part of a capital budget process, bonds with a term of 30 years can be issued to fund the current portion of a capital budget, even if all of the items included in the budget do not have useful lives of 30 years. For example, fire trucks or public works equipment. Third, carefully weigh the alternatives to borrowing. Does the municipality qualify for grant funding? Such grants might finance a portion or all of a project. If a decision is made to pursue a grant, be aware that there may be matching provisions as well as other regulations and requirements. Can the municipality comply with these requirements? Would the costs of complying outweigh the benefits? If a particular project is not needed for a few years, another option is to create a capital reserve fund, a special fund into which monies are regularly deposited in anticipation of capital projects. This fund could be used to reduce or eliminate the need to borrow, thereby saving interest dollars. Fourth, consider financing the project from current revenues on a pay-as-you-go or pay-go basis. Perhaps the costs could be met by levying a one-time tax or fee as another alternative. There are two general approaches to financing capital needs in a municipality. One is the pay-as-you-go or pay-go basis, and the second is a pay-as-you-use or borrowing basis. Some of the factors to consider with either: from a pay-go basis, municipalities must immediately face up to the fiscal realities rather than borrow to defer costs. Pay-go encourages municipalities to take a harder look at the need for projects and the costs involved before undertaking them. Avoiding debt affords municipalities greater flexibility in times of economic downturns because future resources are not committed to paying debt. Municipalities would not be saddled with debt service payments during the times they are least able to afford it. During recessions, capital costs can be cut by postponing projects or reducing outlays without harming current operations. Interest costs are also avoided. The total interest on every $1,000 issued at 5% amounts to approximately $1,580 over 20 years. The pay-go approach avoids this cost. Borrowing capacity is also saved for times when the municipality actually needs it. And finally, debt is not passed on to future generations. Factors to consider on a pay-as-you-use or borrowing basis include: as revenues increase over time, the fixed costs of debt repayment will represent a smaller portion of total revenues. Paying debt should become easier over time. Projects that are currently needed should not be delayed unnecessarily because of low current revenues. This is especially applicable to new or growing communities. Postponement projects might delay the municipality's development and retard growth in its tax base. Borrowing ensures that new residents and future generations using the facilities help to pay for them, as future taxes or user fees go towards debt service. And also, during times of inflation, the dollars used to repay the debt are worth less than the dollars borrowed. Having a formal capital improvement program and budget process that is integrated into a local government's annual budget process, along with a formal debt management program, are best practices that will provide a multi-year focus to address infrastructure needs in a planned and fiscally responsible manner, and if followed, maintain a municipality's fiscal integrity. LGUDA sets forth the procedures to issue the various types of debt and defines responsibilities until the debt is paid. The procedures to follow when issuing debt may seem complex and intimidating, though they are important in ensuring the fiscal stability of local governments. The Pennsylvania Department of Community and Economic Development is responsible for the administration of the Local Government Unit Debt Act, to provide guidance to municipalities on borrowing-related matters, and acts on filings that are made pursuant to provisions of the Act. And I'm now going to turn to my colleague, Tim Anstine, who is going to walk you through the various provisions of LGUDA. Tim?
Thank you, Fred. I prepared a PowerPoint presentation that contains the substance of what I'm going to tell you because I figured you would need that. It's difficult to absorb a lot of this. It's kind of detailed, but I wanted to give an overview of LGUDA and how it works and how it affects the local government units, and then talk a little bit about what the role of DCED is in that process. And to start with, it's important to understand that the source of the debt limits that we have now are found in the Pennsylvania State Constitution. The 1968 Constitution included a provision that required the General Assembly to enact debt limits that would be based upon a borrowing base determined by the revenues of the local government units. Prior to this time, my understanding is that the Constitution, Pennsylvania constitutions that preceded the 1968 Constitution, included the debt limits in the Constitution, and they were based on an assessed valuation of the local government units. In other words, the debt could not exceed a certain percentage of the total assessed valuation of the property in the local government unit. So the 68 Constitution changed that manner of calculating the debt limits because I assume it was thought that the revenues that the local government unit earned from its taxes would be a better reflection of how much debt capacity it could have. It's also interesting to note that the Constitution includes the exclusion for self-liquidating debt that we've talked about or that you've heard a lot about today. That is found in the Constitution. So in response to the Constitution, historically, I believe the Senate in 1968 or 69 appointed a commission to develop the Laguda statute, and it took several years to do that, and then finally in 1972 Laguda was enacted by the state legislature. It's been amended several times since then, and it was reenacted and codified in 1996, but there haven't been that many significant changes with the exception of the swap provisions that were discussed this morning. Now, under Laguda governs local government units, and those are typically your counties, your townships, your boroughs, and your school districts. It also would include any home rule charter local government unit that received its charter after July 12, 1972. Importantly, any municipal authorities or industrial development authorities, other kinds of authorities, they are specifically not considered to be local government units, and the debt that they incur is not subject to the limits of the Debt Act. That's correct. Let me go back and add that the city of Philadelphia is also not covered by the statute or the county, but the school district is in Philadelphia. Under Laguda, debt is classified in several ways. First of all, the debt has to be incurred for a specific project, a type of project that's one of the ones that are enumerated in the Debt Act. The most common types of projects that we see are for the construction and acquisition of buildings and other facilities, infrastructure such as sewer projects, any purchases of equipment, police cars and fire engines and so forth. The other big type of project that we see are refunding projects where, as you heard this morning, a local government unit has incurred debt and then they refund it at a later point, usually to reduce debt service on the original debt. The Act also specifies the costs that can be paid for with debt that is incurred, and it's a fairly broadly defined definition of project costs. Essentially, any costs that are necessary for the acquisition or the construction of the project, professional fees with no stated limitation in the definition, capitalized interest up to 1 year following the completion of construction of the project is permitted as a cost, and what's called reasonable initial working capital in order to operate the project that's being financed. Now, under the Debt Act, the types of debt is further classified as either electoral debt, non-electoral debt, or lease rental debt. Electoral debt, as the name implies, is debt that's approved by the voters in the local government unit, and there are no limits on that kind of debt. As provided in the state constitution, any debt that's been approved by the taxpayers, there's no limit to it. That's a fairly rare type of debt. We don't see many proceedings filed for electoral debt. The biggest category is what is called non-electoral debt, which is when a local government unit issues debt directly for a project that it is undertaking, general obligation bonds and so forth. The third type is what's called lease rental debt. And that term, I think, is a historical term because historically I think in the 1940s, there came into play the authority, what is called the authority method of financing. And that was with the creation of municipal authorities to do utility-type projects that were not on the books of the local government unit, but where the local government unit was leasing the project back from the authority that financed it, and there were payments being made by the local government unit to the authority under lease agreements. So in effect, the taxpayers were paying that debt through the lease payments that were being made to the authority. And so the term lease rental debt came into play to describe that category of debt, but it also includes any other agreement, such as a guarantee agreement, as we see in the case of the city of Harrisburg, where a local government unit is guaranteeing debt that's been incurred by an authority. And those are fairly common types of debt financings that we see. Once you get beyond the broad categories of debt, you get into the types of debt instruments that are issued by the local government unit. They can be general obligation bonds or notes, which I would say is the most common type of debt instrument that we see. These are bonds or notes that are backed by the full faith and credit and taxing power of the local government unit. You can have revenue bonds and notes, which are bonds or notes, the security of which is a pledge of the revenues that are being generated by that particular project. And then beyond that, you can have guaranteed revenue bonds and notes, where the principal payments on the bonds are going to come from the project being financed. But if there's a shortfall in those revenues, the local government unit is backing the debt with its full faith credit and taxing power. And I've given an example of a proceeding for a general obligation note in 2011. Bedford County issued $4,685,000 in general obligation bonds to finance an emergency management system in the county. An example of revenue bonds and mortgages was we had intermediate unit number 1 in Fayette, Greene, and Washington counties issued $3 million in revenue bonds to finance renovations to the central offices. Now, there's a further classification by which debt can be classified, and that is the time period to which the debt relates. Most of the debt proceedings that we see are for long-term projects. And as Fred indicated, the Debt Act does contain a provision that limits the maturity of debt to the lesser of the useful life of a project or 40 years. And there's a requirement in the Debt Act that when a local government unit is financing a capital project, that they must obtain a realistic estimated useful life of the project, so that we can determine whether or not the maturity is satisfactory. But there is an overall limit of 40 years, regardless of the useful life of the project. Second, there's a type of debt called unfunded debt, which Fred alluded to, and this is where basically the local government unit does not have the tax revenues that it needs to pay its current operating expenses. It's miscalculated, and there's essentially an emergency type situation. And in that case, the Debt Act allows for the local government unit to go into the local court of common pleas and apply for approval to fund its unfunded debt. And that's called funding unfunded debt. And there's limits that the court will look at to allow that kind of debt to go forward. There's criteria that have to be established, and there's a limit on 10 years on a maturity of that debt. And I'll talk a little bit more about that later. The third type of debt is an even shorter term obligation, and these are tax anticipation notes or tax and revenue anticipation notes, which are issued in the current fiscal year to kind of tie the local government unit over until it receives its tax revenues, because their expenses are more or less level throughout the year, but their tax receipts may occur only once or twice in the course of the year. So they need a short-term financial instrument to help them kind of bridge the gap. And those are, as I said, short-term instruments that they must mature no later than the end of the current fiscal year. So, having given that kind of broad overview of the types of debt, we get then to the debt limits that are imposed. And as I said, the Constitution required that the General Assembly base these on a percentage of the revenues, of the recent revenues of the local government unit. Under Laguda, the borrowing base of the local government unit is deemed to be the average of the total revenues of the local government unit for the 3 fiscal years immediately preceding the year that the borrowing is being made. And there's total revenues is defined in the Act to include mostly tax revenues and any other revenues that are coming in to the local government unit, exclusive of subsidies that it might receive from the federal or state government that are for a particular project, interest on sinking funds or reserve accounts that it may have to pay project costs, and money from the sale of capital assets, because those are deemed to be, they're non-recurring types of income, so it wouldn't make sense to include them in the borrowing base. And when a local government unit borrows, it must calculate its borrowing base and certify that to our department. And I have an example on page 17 of the handout. I apologize for the difficulty in reading this. I thought that these would be projected, but this was the borrowing base submitted by Aleppo Township in Allegheny County in connection with the borrowing that they made, I believe, last year. And it basically sets forth and certifies what their total revenues have been for the prior 3 years and determines what the average of those revenues are. Now, once you have the borrowing base of a local government unit, the debt limit is then calculated as a percentage of that borrowing base. And I've given them on page 18, actually on page 17 and 18. The debt limits for non-electoral debt are, again, in the case of Philadelphia School District, it's 100% of the borrowing base, 300% of the cap for a county, and 225% of the borrowing base for a school district other than Philadelphia. That's the debt limit for non-electoral debt. Those mostly general obligation bonds and notes that are issued by the local government unit. There's then a higher debt limit that's allowed for non-electoral plus lease rental debt. And the reason that they had this separate limit set out, I believe, had to do with some concern at the time of the enactment of Laguda of having a limitation on the authority debt, which prior to that time had been deemed to be self-liquidating debt. And the Constitution sort of implies that any self-liquidating debt could not be considered as part of the debt limits. So it appears that they attempted to get around what they perceived to be a constitutional problem by having a higher limit that would encompass both non-electoral debt and lease rental debt. And they did that under what was described in the statutory history as their inherent power to regulate authorities, rather than the constitutional mandate to enact debt limits on local government units. So that's why there's kind of two separate sets of debt limits. I've included, again, on pages 18 and 19, printouts from our debt records that we have that show the debt capacity for the city of Scranton and for the city of Philadelphia based on their most recent debt filings. And I can't read it. I could read it on my copy in the office, but suffice it to say, I found it interesting that the city of Scranton has rather significant debt capacity available to it right now, as does the city of Pittsburgh. Now, exclusions from the debt, as I said, the Constitution requires that certain types of debt be excluded in calculating the debt limits for a local government unit. And the basic exclusions are for self-liquidating debt and subsidized debt. Subsidized debt is basically debt where there's going to be payments from the federal or state government in the form of grants to pay for a project or some other kind of subsidy, perhaps a subsidy from the state education department to a school district, where those subsidies are going to be sufficient to pay the debt service on that project. And so that debt is not counted towards their debt limits. That's subsidized debt. The most common kind of exclusion that we see is self-liquidating debt, which is of issue in the Harrisburg situation. And that's essentially debt that is determined to be payable solely or partly from the rents, rates, and charges that are coming from the users of the facility. I would say the overwhelming most common type of self-liquidating exclusion we see is in connection with sewer projects, where the sewer rates and rents are going to be sufficient to pay for the debt service on the sewer project. And I've given an example there of Aleppo Township, which filed exclusion proceedings in connection with that debt proceeding that was shown earlier. Now, the Act does include certain provisions to allow a local government unit to exceed its debt limits. There is a specific provision for counties that have county-wide responsibility for certain programs, and they are allowed to exceed their debt limit up to 100% of the borrowing base. And on page 24, the top slide there lists the specific types of programs that would allow for an increase in debt. Hospitals, flood control, air and water pollution control. These are, projects that are going to broadly benefit the county and its inhabitants, and the determination was made that there should be a higher debt limit allowed for those special projects. The second kind of, shall we say, manner of exceeding the debt limits would be in the case of emergency debt. And that would be, as shown on page 25, when it's necessary, when a local government unit is at its limit for borrowing, but it absolutely needs to borrow for one of the reasons listed on page 25. It's basically, there's going to be a threat to public health or safety. And again, there's a procedure in the Act where the local government unit has to petition the Court of Common Pleas and go in and basically make its case that it should be entitled to incur debt in this emergency. And then the next type of debt that exceeds the debt limit is the unfunded debt, which I had started to talk about a little bit earlier. And again, this is where a local government unit finds that it's unable to pay its current operating expenses or the expenses of a prior year that might have gotten rolled over into the current year. And the Debt Act has a provision for them to go into court and make its case that it should be allowed to fund that. And they must establish that they're unable to raise sufficient tax revenues to pay the obligations, either because of the tax limits imposed on them, because of the timing in the fiscal year, or because it's somehow not in the public interest to do so. And I'm not aware of any emergency filings that have been made since I've been doing it. I don't know, Bernadette, if you have any. It's very rare, I would say, or unfunded debt. But we did have an example actually of Lackawanna County in 2011. We received proceedings where they borrowed $21 million to fund unfunded debt, to pay current operating expenses and outstanding debt. The procedural requirements for borrowing are set forth in the Act. And essentially, if you're going to have electoral debt, there's a procedure that the local government unit goes through to have that referendum put on the ballot and have the results of that election certified to the department. In addition to that, and in all other cases, generally the local government unit must first enact either an ordinance or a resolution after public notice of that fact authorizing the debt. And the ordinance is both an informational tool for the local government unit citizens, and it's the way that the local government unit officially starts the process of incurring debt. And they're required to publish a notice of the ordinance not less than 3 and not more than 30 days before the meeting at which the ordinance is going to be enacted. And then once the ordinance is enacted, they have to publish another notice within 15 days stating that it has been enacted. And in both advertisements must provide that the ordinance is available for public inspection at the government unit's office. Our role in this, DCED filings, the Act provides what are called the proceedings, debt proceedings, and those are essentially the paperwork that's done in connection with the debt incurrence. It would be copies of the advertisements of the public meeting have to be submitted to us, a copy of the ordinance, a copy of the agreement with the underwriter or the bank to make the loan or buy the bonds from them, a copy of a debt statement, which is to be a certified copy or a certified statement of all of the outstanding debt that local government unit has, as well as the borrowing base certificate. In addition, if they want to have exclusions from the debt for self-liquidating or subsidized purposes, they have to file an exclusion report that's been prepared by an appropriate professional, most commonly an engineer, stating that the revenues from that project will be sufficient to pay the debt service, and so forth. The legislative history for Laguna indicates that the submission to DCED and the approval was intended to serve three purposes. One, which was to be a check on the debt limits, and I guess this would be the most important, an accuracy check to make sure that the local government unit is not exceeding its debt limits. The second purpose was to provide finality to the proceedings. That is to say, that they couldn't be challenged in any manner, so that the bonds can be sold and debt can be incurred by municipalities without the uncertainty that might ensue if they could be challenged at a later date. And indeed, the Debt Act provides that once we have approved the proceedings, they cannot be challenged unless there had been a taxpayer complaint filed before our approval. But once our proceedings are approved, once the DCED approval is given to those proceedings, they're deemed to be final and they cannot be challenged in any court proceeding at law or in equity or in any civil or criminal litigation. So the proceedings themselves and the debt that's incurred, it was felt important that it be given finality. We didn't want any uncertainty in the capital markets, which would make it more expensive and difficult for local governments to borrow if the proceedings could be challenged. The third reason for the filing with us is to provide a manner for collecting data on a statewide basis to know, in fact, what the debt load is of all of the local government units in the state. And we maintain on our website, and before that we had written records, detailed records of all of the debt incurrences by the local government units in the state. So when they file with us, the most common error that is made in the filings is that there is a discrepancy between the debt statement that they file with us and what our official record shows as being the debt that they have incurred. Either they have some debt on there that we didn't know about, or we have something showing on our debt records that they did not include in their debt statement. So that's the most common source of error that has to be worked out before we can give our approval. The Act specifies that we have 20 days from the time that we receive the proceedings to act on them. There is a provision for an additional 20-day extension if we feel that we need it, but I'm not aware of that having been used recently in any event. So the point to be made here is that these proceedings come to DCED fairly late in the process. The local government unit has already had their public meeting. They've already incurred the debt by enacting the ordinance. They've entered into an agreement with a bond underwriter to sell the bonds, or with a bank to make the loan. They have all of their project contracts ready. They've got everything that they need to go, and we're sort of the last thing that happens before they close on their loan. And the legislative history indicates that the 20-day period was put in there because at that time, the average time between signing an agreement with a bond underwriter and going to settlement was 30 days. So they thought that 20 days would be sufficient. If we don't act on it in that time, the proceedings are deemed to be approved. And we don't like that to happen, and I don't think it ever has happened. We either act on them to approve them within that 20-day period, or we notify the local government unit that there's some deficiency in their filing, and that stops that 20-day period from rolling on until the deficiencies are corrected. And once they are corrected and we deem that everything's fine, we issue a certificate of approval. Now, with respect to what we do when we get these proceedings, because of the limited amount of time and the volume at least that we get, I think I have a slide in here on page, just to put this in context, on pages 34 and 35, you can see the number of these. It's typically over 1,000 a year. So we're getting 20, 30 proceedings a week from local government units. We're really reviewing to see whether they dotted their I's and crossed their T's. We're not inquiring into the wisdom of the project that's being undertaken. We're not second-guessing engineers. If it's an exclusion proceeding, we want to make sure that they have an engineer's report and that it contains all of the things that are required by the Act, but we're not in a position to second-guess that. The other thing that's required, as was discussed this morning, once a local government unit has incurred debt and has had it excluded on our debt records from their debt limits, When they later incur debt, they have to tell us, they have to certify that those earlier exclusions are still in force, or if they're not, they have to tell us that circumstances have changed and that they can no longer claim those exclusions. But that's a requirement. It's the only requirement in the Act now that allows any kind of monitoring of exclusions that were granted in the past. And we rely entirely on what they tell us. It's typically a one-line certification in their debt statement saying that we certify that there have been no changes that would cause those exclusions to be reduced other than through the normal payment on the debt. You know, amortization of the debt, which would reduce the exclusion. So we look at it to make sure that everything was done. We evaluate the ordinance to make sure that the project that's being funded is one of the projects that the local government is allowed to enact. There are provisions in the Debt Act that govern how the debt can be structured over time. They're generally required to have approximately level debt service on their debt, except for lease rental debt. And what that means is, the thought was, in reading the legislative history, that when a local government unit incurs debt, they didn't want schools and townships and so forth to be able to incur debt where they put off a lot of the burden into later years and onto board, maybe school boards that are going to be in power later. They didn't want to burden those later bodies with the responsibility for that debt. They wanted the debt load to be fairly even. Now, they are allowed to what we call wrap their debt. In other words, they may have 4 or 5 different issues of debt outstanding, and we would look at them in the aggregate and see, when you put all of the debt load together, is it an approximately level debt load? So that's one way of allowing them to structure their debt, an individual debt issue that may not be level, but when you take it in conjunction with all of the other debt issuances, it's still an approximately level debt service on the local government unit. Now, as Bernie just stated, the big exception here is that those provisions having to do with level debt service do not apply to lease rental debt. And if you'll recall, when there's lease rental debt, the actual debt is being issued by the authority, Harrisburg Authority or whatever. The Laguda provisions do not apply to the debt that's issued by the authority, and there's no provision that requires that level debt service requirement be passed, also apply in the case of authority debt that's being guaranteed. So in the case of Harrisburg, it sounds like there was not level debt service. A lot of it was shoved off to the end, and it wouldn't have been a matter that we would have looked at, because we don't, we have no jurisdiction over the authority's debt, and that level debt service requirement is not applicable to lease rental debt. Finally, I just wanted to touch on a couple of kind of ancillary issues related to Laguda to give you just a broader understanding. There are some additional kinds of debts that are authorized in the statute. One is for small borrowings for capital purposes. A local government unit's allowed to borrow up to $125,000 or up to 30% of its non-electoral debt limit without coming in to seek our approval to do so. And this is commonly used to buy police cars, things like that. The aggregate amount of that debt cannot exceed, as I said, $125,000, and the maturity of the debt cannot exceed 5 years. And it can only be used for a capital project, such as the purchase of equipment. And I've given an example there where Gravesburg Borough in Allegheny County borrowed $50,000 to purchase a dump truck. They're not required, again, to get our approval, but typically they would let us know that they've done that so that we can amend our debt records and have them as complete as possible. And I think I've already talked about tax and revenue anticipation notes and the fact that they're short-term financial instruments. They have to be, again, they do not require the approval of the department, but the local government unit is required to file with us a certificate, let us know that they've done this, and file a certificate of the tax revenues and other revenues that they expect to receive, which would then support the issuance of the tax anticipation note of the TRAN. And then I did want to touch basically on the swap provisions. that were discussed this morning, the 2003 amendments to Laguda authorized the local government units to negotiate and enter into these qualified interest rate management agreements, including swaps and interest rate caps and collars, agreements that are intended to manage their interest rate risk. I would echo what was said earlier about the ability of most officials, most local government officials and school board members to not understand really what they're entering into. I don't think a lot of professionals really understand them. The local government unit is required to retain an independent financial advisor when they enter into these what are called quorums, but it doesn't seem like it's worked out a lot. Again, they're not required to get our approval for these swap agreements. They are required to let us know that they've entered into them, and we maintain in our files a log of all the swap agreements that have been entered into by the local government units. And I think I have a number here. Since 2003, we've received over 700 swap filings relating to over 700 different debt issues. It's fallen off dramatically lately because of the interest rate environment. That concludes my presentation. I'll be happy to take any questions that you may have.
Ms. Barratini, are you going to speak as well, or you're just here to answer questions?
I think Tim's pretty much covered the process. Again, the department looks at what's contained in the documents that are in the debt proceedings and the exclusion proceedings. And unless there is a taxpayer complaint, which would raise issues, and then there is a whole administrative process for that, and there was none filed regarding any of the incinerator deals, or unless there's something that on the face of the documents just jumps out at you, or your debt calculations, show problem, there really isn't any way for the DCED people involved in the review to know that what's going on behind the scenes. The department does have limited jurisdiction, and this has been upheld by various court decisions, Commonwealth Court and so on, in regard to taxpayer appeals that have come through the department over the years, that we do not have the ability to second guess the local government officials and their wisdom to do a project. Whether we agree with it or don't agree with it is not the department's job. They have no ability to second guess those types of things. So basically, it's a review for compliance with the statutes and a check of the debt limits and the debt statement information. With regard to exclusion proceedings, the statute does require that the exclusion report be prepared by an architect, engineer, or other person qualified by experience in relation to the project. So, for example, with a golf course, a county golf course, you may see a golf course manager preparing a project. With a sewer project or water project, usually it's the project engineer. With the incinerator project, my understanding is by the time they got to Barlow, that was the only entity that was, or persons who were involved in that particular type of design model. It was something, as I understand it, was new and innovative. And so, yes, Barlow did do the exclusion report in 2003. And again, that is not uncommon to have the project engineer on a water project or sewer project prepare the exclusion report, because they're the ones that are most involved in the project and would know the details. It does have to include a projection of revenues and expenses covering the life of the issue, and there is provision in that section, which is Section 8026 of the Local Government Unit Debt Act. That's the checklist for what you need to file with the department in order to obtain an approval of exclusion proceedings. It does allow you to include other available funds. It's rents, assessments to the users, and any other available funds. So, for example, with a sewer project or water project, if you were getting a PenVest grant or USDA grant, you could include those funds. Or if you had reserve accounts, anticipated earnings over the years, they can make certain adjustments to include other available funds related to the project. So it's not just project, ultimate users assessments. when they actually do their projections of revenues and expenses. If you have any questions, I don't have any specific independent recollection of, I did the reviews for Harrisburg in 2003. Well, I've been doing Laguna reviews since the mid-'80s. For about 26 years. I retired from the state in April. And as Tim said, there would be maybe 700 to 1,200 a year. The staff would usually consist of me, or in my absence, another attorney in the office would be my backup when I would go on vacation. But usually it would just be me and a legal assistant, and in some periods of time I didn't even have the legal assistant. So the department staff is very small. None of us, and I know in my predecessor, nobody that has been involved in administration in Laguna has ever been an engineer or architect or a person trained in, with incinerator projects or retrofits. So it's basically a legal review of the documentation to make sure it meets the requirement of the statute. In terms of project description, we go by what is, your debt ordinance has to identify what you're borrowing for. That's a requirement in the statute. It has to identify the project or projects you're financing, the amount you're financing, the useful life or useful lives of their capital projects. So we go by, or the department would go by, the description of the projects in the debt ordinance. Now, the department has checked, and they don't have the actual proceedings, for example, from 2007. They just have what their computer record, a computer record is created since the mid-'80s. We've had this in place. A computer record is created when debt proceedings are filed, for each debt proceeding. And that would indicate, data is entered as the reviews are done, which would indicate a description of the project as contained in the debt ordinance. So I don't have the actual debt proceedings. They're not kept. The statute, I think, requires the department to actually keep the proceedings for only maybe 4 months. So the department's record is the computer record. And for example, the $30 million 2007 guarantee agreement, it's retrofit project, including working capital component of the retrofit completion project. So there was some reference obviously in that ordinance to the completion of the retrofit project, which would be a capital project, including working capital, a working capital component. They're not required by statute to give you a breakdown of cost.
I appreciate, Tim, in particular, the detail of your walking us through the Laguna framework. There's a couple of things that I said at the outset of the hearing about trying to identify either weaknesses in statute. You might have just identified one with respect to what we require under statute. But I think that the situation here is, and I'm not sure that the chairman will disagree with me, is an issue of that the outputs coming from the department are only as good as the inputs upon which you rely. And it would appear to me, in the case of this project in particular, you have competent professionals who are making an assessment, who are providing you the necessary documentation associated with disposing of it in terms of its legality. And you also have in the case, and Tim, in your latter part of your presentation with respect to the swaps, an independent financial advisor that makes some assessment of it. The thing that I should say that your testimony affirms the testimony we just got from Attorney Goldfield about your capacities and about your role. And it is limited, and it's understood. I think probably the thing that I'm going to ask of you, and I'm not sure how well you can comment on this, but I'm going to put it out there. This issue of the lack of coordination, if you will, between a municipal authority's actions and those of a local governing body. This issue of exclusion and self-liquidating debt, and I guess the issue of the reach of Laguna. It doesn't really, the only reason that anything ever came to you is a function of the guarantee, not on the basis of the actions of the authority itself. So a couple of questions. Let me start with one easier one. One of the things we learned in the previous testimony is that typically the projects that you'll do that will be self-liquidating debt are probably a sewer authority or a water authority where the revenue streams seem to be reasonably predictable based upon the cost of the services being provided. How distinctive was this project? How many Laguna requests do you get involve projects outside of that realm that are dealing with revenue streams that are a little bit less predictable than perhaps the sewer authority?
I defer to Bernadette. I mean, I've been administering the Laguna for about 6 months, and I haven't seen anything.
This type of project, I mean, I don't remember really seeing anything quite like this one. I mean, it was unique. As again, you could get, there have been a few over the years, with counties with golf courses. You know, they would, again, use a golf course, the manager of the golf course to prepare the revenue projections. But the most common are clearly sewer and water projects.
Understood.
You know, you just don't see a lot of this incinerator financings.
I guess the other thing I'm curious about has to deal with these 810B, 8110B. If they are going to be certified to the department, in the case of the city of Harrisburg, they would have had to have been certified by the local governing body of the city. Is that correct?
They're considered part of the debt statement. When they hand in file is a debt statement, a statement indicating their outstanding debt, taking whatever lawful deductions they're entitled to under the Debt Act to come up with their net debt figure. They have to, that has to be prepared within 60 days of filing with the department. It has to be verified under oath or affirmation, meaning verified by, under notary or under municipal seal. The Section 8110B certification, at least the way where it's located, that requirement's located in the Debt Act, that's in the debt statement section of the Act. So usually it's signed off by whoever signs off on the debt statement. And that's usually, you know, the Secretary Treasurer and the, you know, President of Council, or it could be if the auditor or controller, you know, depending on the type of entity, school district, municipality, township, whatever. It's usually, you know, a combination of those officials that sign off.
Just as a point of clarity, though, in the case of a municipality, the mayor and council would have to agree to this by ordinance. It would be embedded in that action by local government. The local governing body would be certifying something to you based upon...
Well, no, the debt statement is just prepared. Usually in your debt ordinance, you're going to have an authorization of certain officials to prepare, certify, and file the debt statement and borrowing-based certificate. So whoever they've authorized in their debt ordinance to do that, that's who's going to sign it. Usually you'll see, like with the city of Harrisburg, I believe it was probably the mayor and controller. With the each school district, it may be, you know, president of the school board and the secretary or secretary treasurer. Sometimes it's done, you know, if they have auditors, they'll have the auditor do the borrowing-based certificate and the debt statement. But it's whoever's authorized in their debt ordinance or debt resolution.
So the officers charged or authorized to do so in their debt resolution. Okay,
Right.
I understand. I guess, again, in the interest of time, Mr. Chairman, I'll defer to you. Thank you very much.
Senator Fulmer.
Thank you very much. Given what you said and told us, it sounds like DCED's review is mostly to be sure the paperwork is complete, but not necessarily accurate. And if that answer is yes, what's the value of a clean certification? It's obvious the process obviously didn't help with the Harrisburg finances. So what's the purpose of a clean certification if especially after what you just told us?
Well, not only with respect to the certification, but with respect to everything that's in the debt proceedings, whether it's the project description or the exclusion report that's done by the figures that are provided to us as far as their revenues and the borrowing. We rely entirely on what's told to us, and if we can't rely on it, then there should be procedures or there should be a method of correcting that, but we do rely on the accuracy and the truth of what's presented to us.
Senator, I would offer that I think that the value in it is the value that it has to the borrower going into the credit market, because the credit market is looking at some, looking at compliance issues with the Act, and that translates into a value of marketing those bonds in the capital marketplace.
Okay, but if that is all correct, then what are the penalties for filing an inaccurate, misleading, or false certification to the department?
The Act itself does not include any provisions. The original version of Laguna, that was the draft that was prepared in 1972, had a very strong perjury provision in it. That was removed from the Act, and the only real mention is in the section that deals with the finality of the proceedings. As I mentioned earlier, once we give our approval, the proceedings cannot be challenged. There's an additional section that says that although the proceedings may be final, it does not relieve anybody from liability for fraud. I believe it's fraud.
I do have to say that when that was recodified in 1996, we were told the intent was not to change anything substantively, just to recodify, but something may have gotten lost in the recodification process because clearly the language is not quite as strong now.
It says, the section giving finality, it says it does not relieve any person participating in the proceedings from liability for knowingly participating in an ultra vires act, meaning one beyond the authority of the government, or from any civil or criminal liability for false statements in any certificates filed or delivered in the proceedings. So the liability has to come from some other source, but it's not in the act itself.
And because of time, I just want to move along here, and thank you for that answer. When the certifications for Harrisburg Incinerator were reviewed by the DCED, were there any concerns or red flags that gave you pause before the certifications were approved for any of the bonds? Because you just said this project was unique. So were there any meetings, discussions, or other special efforts needed for DCED to be satisfied for the certifications you received for the Harrisburg Incinerator were indeed self-liquidating debt?
Okay, at the time, when I say unique, I mean I don't recall any other relating to incinerator project. In terms of the uniqueness of the equipment or the whatever Barlow had designed, I learned about that afterwards, subsequently, as more information came out in newspaper articles. But at the time, it was an incinerator retrofit. They had an incinerator, they had a facility, and they were making improvements on it.
Thank you.
In 2003. And the person that happened to complete the exclusion report happened to be the person that was going to be making the improvements. So I can't honestly say it jumped out as a red flag as it would now, knowing what we know now. And all the other information that Mr. Goldfield mentioned about what was going on behind the scenes or breakdowns of how much was capitalized interest, how much was working capital, how much was fees, again, that wouldn't be part of the, you're not required to disclose that in the filings.
Which leads me to my, I'm sorry. I'm
I'm
sorry,
not
I didn't want to
finished.
interrupt you. Please forgive me. Which leads me to my last question for you. Is that on August 31st, 2011, Dauphin County issued a revised certification for DCED for the Harrisburg Incinerator. From DCED's perspective, and given the ongoing questions about the Harrisburg Incinerator, is this reissued certification significant?
I'm sorry, I'm missing, could you run that by me again?
Right, on August 31st, is this from what we received was that? On August 31st, 2011, excuse me, Dauphin County reissued a revised certification to DCED for the Harrisburg Incinerator. My question is, from DCED's perspective, and given the ongoing questions about the Harrisburg Incinerator, is this reissued certification significant?
I don't know what you mean by a reissued certification. You mean in relation to a new borrowing? They had a,
Well, they revised it, according to what we have here.
I'm not sure what you're, they have a new debt issue and are you, I don't know what you're referring to.
Can bring it down, please.
Just to expand a little bit on an earlier point, the way this works is the local government unit provides us with duplicate sets of proceedings that we review. We keep one, and then we stamp approval on the other one and send it back, and that becomes part of the official transcript for that bond proceeding. So the fact that we don't have those proceedings from the earlier years, they're still available. The party should have them.
Okay, you're, I assume, referring to the highlighted part.
Yes,
Okay.
yes, yes.
When you file a debt statement,
Okay.
if you've had exclusions approved in the past, you can choose to claim them, but you don't have to unless you need them in order to remain within your debt limits. Dauphin County didn't need them in 2007. I don't believe they need them to claim them now. So they chose not to claim them. That's not really, it just says they have elected not to utilize this exclusion in connection with this debt proceeding. What Mr. Goldfield was talking about when he was talking about a clean 8110B certification or revising it downward, that would be one where they would come in and they would want to claim, say, at least a portion of the incinerator debt proceedings or exclusions, and they would say, you know, we're at this time, instead of certifying there's no change in circumstances, they would say something to the effect that due to reduced revenues, only 40% or exclusions in the amount of X dollars can be excluded. That's not what happened here with Dauphin County. This footnote just says they're just not going to use them in this debt proceeding. It's
Okay.
really-
So is that what the
That would-
revision was all about then?
Pardon?
Is that what the revision was all about then?
Well, I assume by 2011, they weren't going to use them because
Okay.
they knew that wasn't,
Okay.
I'm just guessing, but the fact remains, they didn't, once they're approved, doesn't mean you have to use them. You
Okay.
only have to use them if you need them because of debt capacity.
Well, thank you for answering that. Thank you.
Okay, it seems to me like we have a lot of, I think we have a lot of work to do with what you folks do on a regular basis. If we're going to look at this problem comprehensively from a statutory basis and constitutionally, we've got to try to firm things up one way or another. I didn't know that you have no idea where the money goes, apparently, right? They don't have to tell you.
Description,
But it-
general project
Yeah,
description.
so if 99% of it goes to fees and 1% goes to construction, that's okay.
That's supposedly up to the determination of elected officials to determine
Right.
how they spend the money.
Do you have any ideas for us? I have a couple specific things, but do you have any general ideas then that may be one? Do you agree that that's something we should maybe ask for up front? Is more specifics about the breakdown of the money? At least it would be
Certainly could.
something on the record that the public would have to say that this is what was asked for. We'll have to get through that, but particularly with the Unit Debt Act and with DCED's review policy, any specifics you have, we would appreciate it, and you don't have to necessarily give them to us now unless you have somebody jumps out at you, but if you can get that to the committee, Senator Blake or I, we would appreciate that. Has there been, I know you do hundreds of these a year, how many of these are turned down every year?
Well, the way the process has worked, I assume it's still the same since April. When a review's done, if there's something that's not in order, the local government unit, through their representative, whoever made the filing on their behalf, is contacted in writing and told, you know, we have this problem, or we need this information, or this correction.
Right.
And they're given an opportunity to make a correction. Most, you know, I would have to say 99.9% of the time, they're corrected.
Right, that's what I
And
would,
very, very few,
if ever.
right,
Return
and the most common reason for kicking them out is if you don't, that first notice requirement is very specific as to timing and content, and there have been a couple of instances where I had to say, you have to start all over because you didn't give proper notice in accordance with the Debt Act. But a lot of the other errors are things that they can correct. They can amend their ordinance or resolution, or they can correct their debt statement. They can file supplements to their exclusion proceedings to address whatever items have been raised by the department.
You didn't recall any, you had said earlier when you first began that you don't have any specific recollections of this.
No, as I said, I would look at between 700 and 1,200 a year. So, I mean, I know I reviewed Harrisburg cities. I know I didn't review all of Dauphin counties, but I reviewed some over the years, but I couldn't tell you which ones, off the top of my head, but I did review Harrisburg's.
If you knew today If you knew then what you knew today, what you know today, would it make any difference in your decision approving filings?
Well, obviously, from what Mr. Goldfield testified, they had problems going back into the 1990s. Yeah, I mean, but then again, I guess I'd have to ask, from where did that information come? I mean, is the department supposed to be reading newspapers, or because it's more than just, obviously here, we're located in Harrisburg. Yeah, we, see the Patriot News or Penn Live. But, what about throughout the rest of the parts of the state? A lot of what I learned subsequently about the project came through newspaper articles.
But what you just told us was, though, even if you knew that, you couldn't do anything about it.
Well,
I mean, if they certified that this is the case, then that's what you have before you to make your decision. Correct?
I imagine I would ask about it, but if they come back and say this is, we've certified this is correct, I don't know. I don't know what you do.
You have a process if somebody would call you and say, well, you said if you get a complaint,
Yes,
you can
yes.
act on it. But if you just heard something or you had some other knowledge that wasn't an official complaint, what would you do? You would probably just rule on it based on what you had before you.
I think
Let
we
me
have
ask you.
to.
Let me ask you this to close here, because we're running behind schedule again. I see three potential scenarios to try to help with what you're faced with on a daily basis. One would be that we beef up your department and have a more thorough review process. I don't know how. That seems to me to be more remote. That's costly. It would take a lot of time. I don't know how we do that based on the numbers that you have every year that go through your department. Another one would be that we look at, have a more stringent review process for people that maybe are over a cap limit. There's some trigger somewhere in there that if they get to be so much, then you do a review. A third scenario would be you continue with the process you have, but there's real teeth in the afterlife of the approval. If you learn things, if everything that we're learning today is correct, and you found out about this after the fact, that there would be very severe penalties for professionals or others that were involved in misrepresenting things to the department. Do you think that would be a significant deterrent?
I would say unquestionably would be a deterrent, significant penalties.
That's something we can work on, I think. Go ahead.
Thank you, Mr. Chairman, and thank you again to the three of you. The issue of level debt not being applied or to lease rental debt, that analysis that you talked about that you do with respect to, is that an improvement that we might want to consider, where your analysis includes a look at the what I guess I would call not general obligation, it would be the municipal authorities debt?
I think that would make sense, Senator, since obviously the city and the local government unit is on the hook for the debt.
Mm-hmm.
Why shouldn't those provisions also apply?
Okay. And in agreement with the chairman, I think the issue of penalty, the issue of independent third-party reviews, which you really don't have the luxury to do, a different threshold of review, I think, in regard to what you mentioned as the earlier exclusions, sounds to me a little bit here like you had something that happened way back when that continued to follow each transaction. And we heard that a little bit from the previous testimony, and there is a reliance upon that obscures the risk, in my estimation, on the basis of following representations and projections that were never questioned. So, again, per the chairman, any recommendations that can come from the department on how we can make it easier and better for you to do the work that you do, and I do commend you for the work that you do because I know how important and how valuable it is. I know that municipal officials across this Commonwealth depend on you, and that you do extraordinary work within constrained resources. So let me say that, and we'll revisit any recommendations that you can provide the chairman or I on ways to improve and omit the prospect for this repeat anywhere in the state. Thank you.
Okay. One last thing real quick. You had talked a few minutes ago to response to Senator Fulmer's questions about the liability for willful violations or fraud. How is that triggered then? Who starts that? Is that something that you could start on your own, or do you need a complaint to start that, or how would that work?
No, we don't have any any jurisdiction to enforce those provisions.
That simply, go ahead, go
Would
ahead.
have to occur either by a taxpayer or, criminal complaints being filed. Attorney General.
Okay. Well, thank you very much for being here today. You're very helpful.